My Lord, the Honorable Acting Chief Justice, my Lords Honorable Judges, Chairman of the Bar Council, Additional Solicitor General of India, Additional Advocates General, Deputy Solicitor General, Public Prosecutor, President of the Telangana High Court Advocates Association, Registrars, Director of the Judicial Academy, Secretary of the State Legal Services Authority, Secretary of Law and Legislative Affairs, Government of Telangana, respected senior members of the bar, Sri Gandhi, and family members, relatives of Justice G.Radha Rani, dear friends of the bar, we have assembled here today in this full court to bid farewell to Honorable Justice G.Radha Rani, who is demitting office on attaining the age of superannuation after a distinguished and fulfilling career. Lordship Justice G. Radha Rani was born on 29 June 1963 at Tenali, Guntur district to late Srimati Bharata Rajeshwari and late Sri Gurijala Sita Ramaya. Lordship pursued BL from Sri Kattamanchali Ramlinga Reddy Law College, Eluru, and finished her LLM Masters of Law from Usmania University, Hyderabad in the year 2001. Subsequently, her Lordships had also obtained PG Diploma in Human Rights from Indian Institute of Human Rights, New Delhi, and PG Diploma in Intellectual Property Rights from Usmania University, Hyderabad. Lordships further obtained a doctorate in law on the subject Role of Forensic Investigation in Administration of Criminal Justice in India from Usmania University in the year 2009. The Lordship got enrolled as an advocate with the Bar Council of Andhra Pradesh on 10/8/1989 and practiced in courts at Eluru, Vijayawada and High Court of erstwhile composite state of Andhra Pradesh. Thereafter, her Lordships was appointed by direct recruitment as Assistant Public Prosecutor in the year 1998 and as Additional Public Prosecutor Grade 2 in 2007. Her Lordships had also worked as Additional Legal Advisor in the Director General Anti-Corruption Bureau in 2008. Lordship commenced her distinguished career in the judicial services in the year 2008 when her Lordships was selected by direct recruitment as District and Sessions Judge, Hon'ble. Thereafter, her Lordships worked in different district courts at Hyderabad, Sangareddy, Secunderabad until she was promoted as Principal District Judge. The Lordships got promoted as Principal District Judge of Nalgonda and worked from 2016 to 17 and as Principal District Judge Rangareddy District from 20 to 21. The Lordships had also served as Metropolitan Sessions Judge Hyderabad and as Chairpersons of the Telangana Value Added Tax Appellate Tribunal. Thereafter, her Lordships was appointed as Judge of this Honorable Court for the state of Telangana on 15/10/2021. During her tenure as the Judge of this Honorable Court, her Lordships in a span of 675 days had disposed of 5,375 main cases, 6,801 miscellaneous cases. Many of her Lordships' judgments are reported spanning various fields of law. To name a few of the notable judgments, in Pramila Bai versus Rukmini Bai, reported in 2022 SCC Online, Telangana, 1532, her Lordship, sitting along with Justice P. Naveen Rao, authored the judgment. Her Lordships adjudicated upon a matter concerning Section 5(1) of the Hindu Marriage Act 1955, which lays down the essential conditions of a valid marriage. The case before the family court involved a dispute between the first wife, respondent defendant, of the deceased and the second wife, appellant plaintiff. Before the family court, the appellant wife instituted a suit seeking a declaration as the legally wedded wife of deceased E. Lakshman Rao. The appellant also sought a direction to the pension authorities to remit 700 per month to the first wife in accordance with the prior compromise decree passed by the family court. The deceased was employed as a traveling ticket examiner in the South Central Railway and was receiving a pension post-retirement. During his lifetime, part of this pension was being disbursed as maintenance to the respondent defendant. The defendant asserted her status as the legally wedded wife and argued that any subsequent marriage contracted by the deceased during the subsistence of their marriage would be void ab initio under the Hindu Marriage Act 1955. The trial court declined to pass a decree in favor of the plaintiff. The plaintiff preferred appeal before this honorable court. Upon examining the record, her lordships found that all the witnesses had admitted the subsistence of the first marriage at the time of the plaintiff's marriage with the deceased, thereby rendering the second marriage void from inception under Section 5(1) of the Hindu Marriage Act. Lordships relied on the judgment of the Supreme Court in Srimati Yamunabai Anantrao Adhav versus Anantrao Shivram, observing that Section 12 of the Act applies to voidable marriages and not to marriages in contravention of 5(1). Her lordships further held that marriages under 12(2) are void ab initio but require fulfillment of specific conditions and a challenge by the aggrieved party to be annulled. Conversely, marriages under Section 11 are void ipso jure, invalid in the eyes of law from the outset. Additionally, her lordships also held that medical card of the deceased bearing the photograph of the appellant does not constitute valid proof of marriage, nor would it establish nominee rights. The appellant failed to produce any decree of divorce or legal dissolution of the earlier marriage with the respondent defendant. Consequently, her lordships dismissed the appeal and held there was no credible evidence of a valid marriage between the plaintiff and the deceased as per Hindu rites and customs, and that the marriage between the defendant and the deceased legally subsisted. The judgment is a clear reflection of her lordship's steadfast commitment to upholding the substantive and procedural law in accordance with the statute. Her lordship's judgment ensured that marriages solemnized in good faith and in accordance with law are not casually undone or invalidated by strategic litigation. In PepsiCo Inc. versus New York versus McFest Beverages Limited, reported in 2023 1 ALD TS Division Bench, her lordship sitting with Justice P. Naveen Rao authored the judgment. Her lordships was dealing with a city civil court appeal filed by PepsiCo challenging the trial court's dismissal of its suit for trademark infringement and copyright violation. The dispute concerned PepsiCo's internationally recognized trademark Mountain Dew, which though adopted in 1940 in the US, was introduced in India in only January 2003 and was duly registered. PepsiCo alleged that the defendants were marketing packaged drinking water under the identical trademark Mountain Dew and used labels resembling the same, with a clear intent to mislead consumers and exploit the brand's goodwill. The defendants asserted that the defense of prior use since 2000 and contended that they adopted the name in good faith for its natural connotation and denied any knowledge of PepsiCo's product Mountain Dew. They argued that PepsiCo's product was not launched in India until 2003 and claimed that registration for a different class of goods did not confer exclusive rights over the mark for packaged water. Lordships identified the key issues, and to name a few: whether PepsiCo had valid registration of a disputed mark, whether the defendant infringed PepsiCo's trademark rights. Upon examining the evidence, her lordships held that the trial court's interpretation was flawed and inconsistent with settled legal principles. She observed that to claim prior use, the defendants had to demonstrate usage predating PepsiCo's registration or global reputation. The defendants failed to produce such evidence. Lordships further held that PepsiCo had established trans-border reputation in the mark Mountain Dew, which had extended to India prior to 2000. Citing Section 124(4) of the trademark, her lordships held that the findings of the Intellectual Property Appellate Board were binding on the civil court, and the trial court had held in questioning PepsiCo's exclusive rights. Accordingly, the appeal was allowed, and it was held that PepsiCo retained exclusive rights over the Mountain Dew trademark, and the defendants had infringed its copyright and engaged in passing off. This judgment is a strong reflection of her lordship's commitment to protecting intellectual property rights and commercial reputation against deceptive practices. Her lordship's academic background and study of the subject intellectual property rights from Usmania University contributed to this jurisprudence. In Garikapati Venkateshwara Rao versus Union of India, Her Lordships dealt with the issue of whether a travel ban imposed on the petitioner without giving a prior notice to him is violative of Article 21. The petitioner was the director and chairman of GVR Infra Projects. GVR Infra Projects availed a loan from the erstwhile Vijaya Bank, which had merged with Respondent 7 and 8 Bank, presently named as the Bank of Baroda. The petitioner was alleged to have stood as a personal guarantor for loans availed by GVR Infra Projects and was consequently subject to a lookout circular issued at the instance of Respondent 7 and 8, that is Bank of Baroda, prior to the repayment of dues. The petitioner contended that LOC asserting that it was issued without prior notice or material evidence. He also contended that the corporate debtor had undergone resolution under the corporate insolvency resolution process with the approved resolution plan settling a portion of the debt. The respondents averred that in spite partial recovery through insolvency proceedings, a significant outstanding amount of 226 crores remained unpaid. They highlighted that the petitioner along with other promoters had previously defaulted and made limited repayments amounting to 14 crores. Given the magnitude of public funds involved and the petitioner's travel booking to the Maldives during ongoing legal proceedings, Bank of Baroda reasonably apprehended an attempt to evade the jurisdiction of the court, warranting an issuance of LOC. Upon careful examination of the records and applicable office memorandum dated 12/10/2018, Her Lordships concluded that the issuance of the LOC was justified. As a personal guarantor, the petitioner was liable for a substantial sum of public money. The LOC was issued not only to ensure accountability, but also to cover economic offenders threatening national financial interests. Lordships accordingly dismissed the writ petition, affirming the LOC served a legitimate public interest. This judgment underscored Her Lordship's principled commitment to preserving the integrity of financial institutions and protecting public funds from misuse or evasion. In Kapulamari Kalyan Srinivas Rao versus Central Bureau of Investigation, Bangalore and another, reported in 2022 2 ALD 820, Her Lordships dealt with the issue of the scope of Article 226(2) of the Constitution, which was invoked by the petitioners to review the action of Additional Chief Metropolitan Magistrate Egmore, Chennai, in taking cognizance of offences under IPC. The facts of the case are that the petitioner filed writ of certiorari seeking the prayer to call for records in CC 3449 of 2018, pending on the file of the Additional Chief Metropolitan Magistrate Egmore, Chennai, and to quash the charge sheet in RC number 4 of 2016. The petitioners, namely A1, the then manager of Best and Crompton Projects, and A2, the company itself, were accused of criminal misconduct in connection with credit facilities extended by a consortium of banks led by the Central Bank of India. The Central Bank has sanctioned 120 crores in working capital, both fund-based and non-fund-based, secured by immovable assets and corporate guarantees. The company defaulted on payment obligations, prompting the complainant. A complaint by the Assistant Manager of Central Bank of India, the Central Bureau of Investigation, Bangalore, filed an FIR, charging the accused under sections 120B and sections 420, 468 and 471 of the Indian Penal Code. The prosecution alleged that between 2010 and 2013, the accused were part of a criminal conspiracy and submitted forged documents in support of letters of credit without any actual movement of goods, and had fraudulently availed credit facility which were then diverted for unauthorized purposes. The petitioner A1 argued that he was not in service at the time of loan sanction and thus would not be part of any conspiracy. He further contended that the allegations were civil in nature and lacked the requisite criminal intent under section 420 of the Indian Penal Code. The learned Additional Solicitor General objected to the maintainability of the writ petition under Article 226 and 227, contending that cognizance was taken by a competent magistrate in Chennai and therefore the High Court of Telangana lacked territorial and supervisory jurisdiction. It was argued that under Article 227, only the High Court of Madras, which exercises superintendence over the trial court, had the authority to entertain such a writ or call for records. Lordships, after considering the submissions and relying on precedents laid down by Apex Court, observed that the evolving jurisprudence under 226(2) clarified that the concept of cause of action in criminal proceedings must be interpreted differently. While civil matters may permit jurisdiction based on a partial cause of action, in criminal matters, territorial jurisdiction must rest with the High Court having supervisory control over the subordinate code under the Code of Criminal Procedure. Lordships held that mere existence of a fragment of cause of action in another state would not suffice to sustain jurisdiction. Accordingly, the writ petition was dismissed with a clear finding that only the High Court of Madras had the jurisdiction to entertain any petition for quashing proceedings or calling for records pertaining to the ongoing investigation or trial. This judgment exemplifies Her Lordship's commitment to disciplined constitutional interpretation, reaffirming that judicial review under writ jurisdiction is a duty to be exercised with precision and restraint, and negating that writ jurisdiction is not an unruly horse. In Kodur Pedayala Reddy versus Kodur Ram Reddy, reported in 2024 6 ALD 25, Lordships was dealing with a second appeal where the appellant plaintiffs have approached this Hon'ble Court against the order of a lower appellate court which set aside the decree granted by the trial court in favor of the plaintiff's appellants. The facts of the case are that the father of the plaintiff and the great-grandfather of defendant number 1 were brothers. During partition between them, the land was divided, and then the defendant's father sold the suit land to the father of the plaintiffs under private sale deed dated 11/5/54 for a consideration of 490. The name of the father of the plaintiff was recorded in the revenue records as possessor, and after the father's demise, they were in possession and enjoyment of the suit schedule property till filing of the suit. The plaintiff asserted ownership over the suit property on the basis of a private sale but did not advance any claim under adverse possession. The trial court, however, decreed the suit in their favor, holding that since the plaintiffs had been in possession of the land over 40 years, they had perfected their title by adverse possession. Aggrieved, the defendants' respondents challenged this decree before the lower appellate court, which set aside the decree of the trial court. The plaintiffs then approached this High Court by preferring a second appeal. Her Lordships framed and considered a couple of issues, and one of the substantial questions of law was whether the plaintiffs have pleaded purchase from the landlords and would subsequently assert title by adverse possession. Relying on precedents of the Honorable Supreme Court, Her Lordships held that in the absence of specific pleadings or issues framed by the trial court on adverse possession, such a finding would not be sustained. It amounted to an error apparent on the face of the record. Lordships relied on Mohanlal through LRs versus Mir Abdul Ghaffar and reiterated the principle that courts cannot grant relief beyond the scope of pleadings. Lordships examined the records and held the appellant's failure to establish continuous and inconsistent possession was further highlighted by the revenue records, where their names appeared only in the year 91-92. Additionally, Exhibit A1, which is an unregistered sale deed, would not be treated as a valid proof of title. Accordingly, Her Lordships upheld the judgment of the lower appellate court, concluding that it had rightly set aside the trial court's decree. The decision reflects Her Lordship's steadfast commitment to procedural discipline and the legal principle that claims inconsistent with pleadings, especially those invoking adverse possession, cannot form basis for judicial review. Beyond the bench, Her Lordships always led a balanced life. Lordships enjoys watching movies, reading, and is very passionate about photography. Lordship's father, Sri Gurjala Sita Ramaya, was a well-known humanist. Lordships is a progressive thinker and had always been proactive about addressing issues relating to caste and human rights. Lordships has also imbibed the same qualities as her father and is a humanist herself. Her Lordships always advocated for the removal of caste barriers in India. In the year 2017, while serving as a Metropolitan Session Judge Nampalli, Her Lordships, during a community policing initiative program, addressed the importance of counseling sessions for young couples who were filing frivolous petitions against each other. And counseling for such couples plays a crucial role, not just as a corrective step in times of distress, but as a preventive and empowering tool for couples. In the year 2022, as a judge of this Hon'ble Court, Her Lordships had addressed the importance of ending the caste system in India. At the 50th anniversary of Kula Nirmulana Sangam, Her Lordships said, caste-based thought is a malice in the society which needs to be removed. Lordships emphasized that caste as a whole is a wrong concept. Lordships also emphasized that honor killing in the name of caste must stop, and the law must protect freedom and equality of the people. Lordships also believes that caste is the root cause of deep and lasting injustice in society. Her Lordship's noble thought of a casteless society, a vision which every youngster should strive to achieve. Lordship's courtroom was always one where dignity prevailed, whether it was a senior counsel or an young advocate, were all treated equally. Lordships is married to Sri S.L.N. Gandhi, who served as an additional commissioner of transport and has retired. Sri Gandhi, not only a retired senior officer of the state government, but is also an academician who has authored an authoritative book on transport laws. They are blessed with two daughters, Mrs. Chetna, an attorney and legal consultant, and Dr. Manavi, MBBS, and a specialist in radiology. As your Lordship steps into this new chapter of life, may you find the fulfillment and purpose that you brought to your judicial calling. Though your Lordship leaves the bench, your Lordship's judgments, values will continue to guide the legal fraternity. On behalf of the entire legal fraternity, I extend my best wishes to your Lordship's retirement as judge of this Hon'ble Court and wish your Lordship success in all future endeavors.
My esteemed colleagues on the bench, Shri B. Narasimha Sharma, Learned Additional Solicitor General of India, Shri A. Sudarshan Reddy, Learned Advocate General and his team, Shri P. Nageshwar Rao, Learned Public Prosecutor, Shri A. Narasimha Reddy, Chairman, Telangana State Bar Council, Shri G. Praveen Kumar, Learned Deputy Solicitor General of India, Shri A. Jagan, President, Telangana High Court Bar Association and his team, Learned Senior Counsel and members of the Bar, Registrar General and his team of registrars, Director, State Judicial Academy, Member Secretary, State Legal Services Authority, Law Secretary, Secretary, High Court Legal Services Committee, Learned Advocates, family members of Learned Sister Dr. Justice G.Radha Rani, friends from print and electronic media, ladies and gentlemen. We have assembled here today to bid a warm farewell to Sister Dr. Justice G.Radha Rani as she demits her office upon attaining the age of superannuation. She was born on 29th June 1963 in Tenali, Guntur district to late Srimati Bharata Rajeshwari and late Shri Sita Ramaya. She completed her matriculation from Andhra University, Visakhapatnam, followed by intermediate and Bachelor of Science degree in Chemistry, Botany and Zoology from VSR College, Tenali. She then did her legal studies and obtained her Bachelor of Law degree from Sir C.R. Reddy Law College, Iluru. She earned a Master of Law LLM from Osmania University, Hyderabad in the year 2001. She also obtained a postgraduate diploma in Human Rights from the Indian Institute of Human Rights, New Delhi, and a postgraduate diploma in Intellectual Property Rights from Osmania University. In recognition of her academic rigor and scholarly dedication, she was conferred a doctorate in law by Osmania University in the year 2009. She enrolled as an advocate with the Bar Council of erstwhile state of AP on 10th August 1989 and practiced at Eluru, Vijayawada and the High Court in Hyderabad. She was appointed by direct recruitment as an assistant public prosecutor on 15 June 1998 and subsequently elevated as additional public prosecutor grade 2 in 2007. In 2008, she served as additional legal advisor to the Director General of Anti-Corruption Bureau. She was selected through direct recruitment as a district and sessions judge entry level. She served with distinction at Hon'ble, Hyderabad, Sangareddy and Secunderabad. Her judicial career further advanced as she took on important roles including Principal District Judge of Nalgonda, Metropolitan Sessions Judge of Hyderabad, Chairperson of Telangana VAT Appellate Tribunal, Hyderabad, and Principal District Judge of Rangareddy District. She was appointed as a judge of this court and assumed charge on 15th October 21. I have no hesitation to say that her rich and diverse experience in the district judiciary significantly contributed to the effective discharge of her duties as a judge of this court. During her tenure as a judge of this court, she adjudicated 5,375 cases. I had the occasion of sharing the bench with her for nearly 2 months, where she contributed a lot. I appreciated her keenness to hear and decide the matters within a short time. Because of her involvement and contribution in the bench, we could decide sizable number of contested matters during the tenure on the said division bench. Sister Justice Dr. Radha Rani is happily married to Shri C.L.N. Gandhi, who retired from state government service as Additional Commissioner of Transport. They are blessed with 2 children, Mrs. Chetana, attorney and legal consultant, and Dr. Mrs. Manavi, MBBS MD. On my own behalf and on behalf of my esteemed sister and brother judges, as well as the entire judicial fraternity of Telangana state, I take this opportunity to bid a heartfelt farewell to Sister Dr. Justice G.Radha Rani. We extend our warmest wishes for a happy, peaceful, and fulfilling post-retirement life. May she and her family be blessed with continued health, peace, and prosperity in the coming years. Thank you.
My Lord, the Honorable Acting Chief Justice Sujay Pal, my esteemed sister and brother judges, learned Advocate General Sri Sudarshan Reddy Garu, learned Chairman Bar Council of Telangana Sri A. Narsimha Reddy Garu, learned Additional Solicitor General of India Sri B. Narsimha Sharma, learned Additional Advocate General Sri T. Rajnikant Reddy Garu and Sri Imran Khan Garu, the Public Prosecutor Sri Palle Nageswarrao Garu, the President High Court Advocates Association Sri A. Jagan and his team of office bearers, learned senior counsels, learned special government pleaders, assistant government pleaders and standing counsels, learned members of bar of High Court Advocates Association and members of other bars in the Telangana state, the Registrar General Sri S. Govardhan Reddy and his team members, my family members, my friends and relatives, ladies and gentlemen, a very good afternoon to all. I am extremely grateful to all of you for this warm and affectionate farewell. I am deeply moved and touched by the generous words expressed by the learned Advocate General on behalf of the bar and the Honorable Acting Chief Justice on behalf of the bench and registry. I am deeply touched by the addresses of the learned Advocate General and my Lord Acting Chief Justice and for the warmth showered on me. I am happy to share that my parents, late Sri G. Sitaramaya and my mother Rajeswari and my family members, my husband, C.L.N. Gandhi, and my 2 daughters, Chetana and Manavi, gave me the best support to enable me to occupy this position. My father is a rationalist, humanist, and practiced atheism throughout his life, though he is not well educated. He had a civil marriage for himself and performed civil marriages to all his 4 children. He performed intercaste marriages for me and for my brother. I learned from him the analytical and rationalist approach. I am also an atheist and critical thinker, which helped me in progressing in my life. I am the first generation literate from my family, the first generation graduate, law graduate, postgraduate, and a doctorate in my family as well as in the entire extended family. I am also the first generation government employee, judicial officer, and first to occupy this constitutional post. The journey of my life from being a homemaker and being a mother of 2 children at an young age, entering into prosecution service and judicial service, and reaching this position is not an easy one. But I rose from each stage with hard work and unwavering support from the family. The brought up from my parents and the support from my family members helped me to balance my family life and my career. I am happy to state that I converted my limitations as opportunities to be in a position like this. I am grateful to the Honorable Chief Justice Sri Raghavendra Singh Chauhan, who recommended my name to this position along with his collegium members, Honorable Justice M. Ramchandra Rao and Honorable Justice A. Rajshekar Reddy. I am also grateful to the Honorable Supreme Court Collegium headed by the Honorable Chief Justice of India, Sri N.V. Ramana, along with 2 Honorable Senior Judges who approved my selection to this coveted position. I am grateful to the President of India for issuing my warrant of appointment to this position. My journey through the corridors of justice has been guided by one fundamental truth, that the rule of law is not just a principle, but the soul of a just society. I have striven to uphold these consecrated principles to interpret the law fairly, without fear or favor. I believe that a judge is not merely a decision maker, but a custodian of trust. I am deeply thankful to my brother and sister judges for their wisdom, support, and the intellectual strength given to me in discharging the duties of this office. I had the valuable advantage of sharing the division benches with the Honorable, the Acting Chief Justice Sri Sujay Pal and Honorable Justice Sri P. Naveen Rao, which enriched my knowledge. In my 27 years of service, both in prosecution and judiciary, I worked mostly in Telangana districts. I thank the advocates, both in districts and in the High Court, for their support. I believe that the courtroom is our shared space. Your knowledge, eloquence, and fearless advocacy enriched the process of justice. To quote Nani Palkiwala, a lawyer's duty is not to his client alone, but also to the court, to the law, and to the larger cause of justice. I acknowledge the support given by the bar members and staff in discharging my duties with diligence. I thank the registry, staff, and officers of the court for their commitment behind the scenes, which enabled the silent machinery of justice to run smoothly. Without their unstinted support, the wheels of justice would not have been moved forward. I express my gratitude to my family, especially my spouse, who is behind me as a friend, philosopher, and guide. I thank my children for their patience, love, and sacrifice, for whom I could not give my time due to the demand of my job as a judge, consuming long hours and an undivided mind. But behind every judge stands a family who bears that invisible weight. Justice Ruth Bader Ginsburg said it beautifully. My mother told me to be a lady, and for her that meant be your own person, be independent. From the strength given by my family, I found the balance that this demanding role required. I also want to acknowledge the support given to me by this High Court when my husband was critically ill. The strong moral support and financial support from this High Court and personal attention paid by the Honorable Chief Justice, presently Judge of the Honorable Supreme Court, Justice Vijal Buyan, Justice Honorable Chief Justice Alok Aradhe, presently Chief Justice of Bombay High Court, our Acting Chief Justice Honorable Sujay Pal, has been invaluable. I also acknowledge the assistance rendered by the Principal Secretary of Honorable Acting Chief Justice Ali Muhammad Sarfaraj and other staff of ACJ Peshi, and the medical protocol staff Johnson, Siraj, Pandu. I am truly grateful to them for the help rendered to me and my family. I thank my personal secretary, Srimati K. Tulasi Lakshmi, Additional PS N. Sailesh Kumar, Court Officer Tulja Singh, Court Masters Sravanti, Navina, Sravani, System Assistant Arunasri, Law Clerk cum Research Assistants Gautami Sindura, Meghana, Shashank Reddy, Joel, Nikhil and Leela Maheswari. Attenders Sunil and Ishak, Driver Kashinath Maharana, PSOs Srinivas, Gulamwali, Nurse Reddy and Muhammad Azam, and Posting Clerks Nagaraju and Rajkumar for rendering their assistance in discharge of my official duties with their sincerity and commitment. They are like an extended family assisting me in my work. I personally thank the protocol personnel Sri P. Sridhar Rao, Registrar OSD, Sri S. Srinivasulu, Pavan Kumar and Narayana for their service and assistance. I also thank my personal resident staff, Bhanumati, Srilata, Vikram Singh, Radhika, Raju, resident security staff, Guardian Malis for their support, domestic help and service in making our lives comfortable at home and for also maintaining a beautiful garden. I am also thankful to my friends and relatives who came from far off places to be present here on this day. Looking back, I feel content, yet conscious of how much more there always is to be done. I hope I leave behind a small mark of fairness, of compassion, of fidelity to the Constitution. As I step away from active judicial life, I carry with me the timeless values that have shaped me, fairness, humility, and a deep reverence for the law. Thank you all for being part of this journey, for challenging me, supporting me, and allowing me the honor to serve. May our courts forever remain the guardians of liberty and the protectors of truth. I take leave from all of you with all happy memories and contentment. I wish all of you the best in your career. Thank you all.